Hi, this is attorney Justinian Lane of Justinian Associates, and this is attorney Dustin Fox with me today. And we want to start off by giving a warm shout out to Mr. Molson Wood of Austin, Texas, who
Absolutely.
He reached out to us to talk about our commercial. You've probably heard the jingle. We really appreciate your feedback, Mr. Wood, and just because we want to thank you so personally for your comments, we have a few extra verses of our jingle for you.
Yeah, absolutely. We'll give it a shot anyway.
All right, I promise we're better lawyers than we are singers, but if you're in a wreck and need a check, call 980-0000.
If you hurt your head and you need some bread, call 980-0000. If you were hit by a truck, we give a hoot. Call 980-0000.
Seriously, we really are better lawyers than we are singers, but I bet somebody out there is actually really good at this. If you'd like to come on down to the studio and you put a couple of verses down, maybe you have a couple better ones than this, please reach out to us or send a video to us. We'll put it on Facebook or we'll bring you down here and you get to come on, see how it's all done, sing a couple of verses and have a good time with us. And today we've got a couple of interesting topics to talk about. We saw in the news that a lawsuit has been filed against Apple over a car crash that happened, and the driver responsible for the crash was using Facetime while driving, which is just obviously a terrible idea. I think it's an interesting lawsuit for a couple of reasons. One of the basis of the lawsuit is that Apple had the ability to prevent Facetime from working while a vehicle is traveling at a rate of speed. And it's because Apple actually patented that technology in 2008. What do you think about this lawsuit, Dustin?
Well, I find it very interesting. For those of you who don't know what FaceTime is, it actually allows you to flip the camera around and talk to folks live while you're on the telephone. I find it very interesting in the fact that they had the technology to lock out their ability while driving and just traveling at a high rate of speed. And I don't know the details on that as to why it wasn't functioning correctly, or was it not installed? Do you know?
From what I can gather, Apple patented this technology, but they didn't actually implement it. And if I had to hazard a guess, Apple figured, well, just because a phone is moving at a high rate of speed, we don't know if the person's driving, a passenger in a train, et cetera. Mm-hmm. So, I think it's interesting that the technology certainly exists, that they could turn that off. And I'd be curious to see how this case turns out. One of the things that is critical if this case is going to work is when you're saying a product is defective, when you sue over a defective product, you typically have to prove that there was some sort of a safer design that you could have used instead of the design that you actually used. And a lot of times you'll have to spend a lot of money to prove up that design. But in this case, all the family will have to do is their attorney will show, well, look at this patent. So we know that design exists. I'm not sure. I'm on the fence, though, if I think that Apple should have a responsibility to lock out those features. What do you think?
Well, that's surprising to hear since we're both plaintiffs' attorneys. But yeah, I can kind of see that. Especially, you don't know what kind of kinks. I mean, just having the patent alone doesn't make it, capable working patent.
Right.
It takes a lot of money to get it installed. You got to test. I mean, who's to say that it would have worked to begin with?
Absolutely. Just a patent is not a working product. And you would certainly know, you have a little bit of experience with patents.
Yes,
stuff.
I did. Yeah, during law school, I actually had an internship at Pfizer drafting some organic chemistry patents. So this is a little bit different since I don't have like an engineering background to fully understand this type of patent. But we would often file patents that, you didn't even think about using. So the functionality itself doesn't really come into play, I guess.
Right. Now, another interesting point that this will bring is, there have been studies that have shown that texting while driving is some number of times more dangerous than drinking and driving because, even if you're drunk, in theory, you're still looking at the road. But if you're texting or video conferencing, you're completely not looking at the road. So a question will come up against the driver if punitive damages should be available. What do you think about that particular issue? If someone is texting or video conferencing, should punitive damages apply?
I would think so. I mean, given the fact that it's so much more dangerous than just driving while drunk, and you have punitive damages that are available while driving while drunk. So, for those out there, can you explain a little bit what punitive damages is? What's the intention and what they are? Yeah,
absolutely. I mean, punitive it's designed to punish. Like if you get in a car accident and you have to replace the other guy's car, that's just making them whole again is what they call it. You're just replacing what you broke. Punitive damages are only available if your conduct is, and it depends on the state, but sometimes it's reprehensible, sometimes it's intentionally disregarding the safety of others.
Language always differs, but
Yeah, but the gist of it is you did something that you really knew could hurt somebody, so we want to punish you for that. So the argument in this case for punitive damages would be anybody should know that driving and video conferencing is so dangerous that they should be punished for that. So I believe, I'm a big believer in punitive damages, that it can deter bad conduct, and certainly anything we can do to deter people from texting or conferencing while driving, I think we should do.
yeah, sure, absolutely. I mean, that's the biggest reason behind it, is a deterrent, making sure folks understand that there are big consequences for something like this, and you don't do it anymore.
Absolutely. And one of the other interesting things about punitive damages is very rarely, if ever, do insurance policies cover punitive damages, because, again, the intent is to make sure that you are personally punished for what you did. So it kind of takes the point away from that if I can just have my insurance policy cover it. So in this case, if punitive damages are awarded, then the driver of the vehicle would personally be bearing the cost and not a car insurance company.
Yeah, absolutely. You came up with a great example earlier, is that you can't insure against going to jail for a criminal act, which
Right.
is the same concept right here.
Right. And speaking of which, whether or not the driver ends up paying punitive damages or his insurance company pays it punitive damages, juries never actually get to know that information, do they?
No, actually, that's one of the rules of evidence, is that you aren't allowed to know whether or not insurance is in play.
Right, and we found, in Texas especially, it's a very quick way to get your case. It's called a mistrial, where it's a do-over. You have to start the whole thing over. Is if you mention or imply that insurance is involved. And saw in the news a while back, there was a Florida firm that got into the news because they were putting commercials on TV.
Oh yeah, I recall.
Yeah, that was letting jurors know that, hey, the odds are that if you're sitting in court for a jury trial, there's insurance coverage. What did you think of those commercials?
I thought they were fantastic. I thought that was general knowledge that the entire nation should really know about, because these are the type of rules that prevent us from telling the whole story that's involved. In fact, there was a jury trial I had a couple months ago where I was second chairing, and the defense counsel led the jury to believe that the defendant herself was going to have to be paying for all what they awarded. So I thought that was kind of a sketch move by the defense counsel, since we're handicapped.
That's a very sketch move, Dustin. I would love to be able to tell every jury, oh, by the way, the other driver in this case has a $100,000 insurance policy, so when you award the money, there's $100,000 to play with before they have to even do anything. I would love to be able to tell the jury that, but we don't get to do that.
No, we don't. There's several different rules we don't get to, but that's one of the most frustrating ones, I'd have to say.
One thing that is a little different with punitive damages is you do get to inform a jury what the net worth of a defendant is. So when they're assessing punitive damages, they get to take into consideration, well, this company is worth $100 million, so they might want to maybe award higher punitive damages versus a small business that's only worth $100,000.
Sure.
So that's one of the big differences is even in that case, you still wouldn't get to disclose whether or not insurance pays. And I understand the principle behind that is that they don't want the jury to just focus on whether or not somebody has the ability to pay.
Sure.
But go ahead.
Well, I was going to say, also informing them of their net worth is going to be really important, because it was to punish them. So, I mean,
Right.
$100,000 to a small business owner is going to be significantly different than someone, say, Apple, or another
Yes.
large company.
Yeah, absolutely. I mean, a $100,000 punitive damage award, I forget how many tens of billions that Apple has sitting around. They're not going to notice. I mean, they make that an interest in a week, so it's not exactly a punishment.
Exactly.
Yep. So I thought that was interesting, and that was a Texas case. And another thing that happened going on kind of closer to home is in Texas. I'm a big fan of Blue Bell Ice Cream. Do you like that?
Love it.
Yeah.
I probably ate too much over the holidays.
I bet a lot of folks did.
Yes.
It was unfortunate, a couple of years ago that they had some listeria that was unfortunately in their ice cream and killed some people. And I saw that they're in the news again that they have had to inspect their ice cream at a higher safety standard than other ice cream companies because of that outbreak. And now they think because the ice cream has been safe for so long, they'd like to go ahead and go back to the lower standard. What are your thoughts on that?
Tough spot to be in again. As a plaintiff's attorney, I really enjoy our food products that we eat, our roads being safe, and all of those safety standards really help ensure that the food that we eat is not going to, one, injure me, or really, unfortunately, maybe even kill one of us.
Right.
So it's a tough spot. On the other hand, it does cost them significantly more money whenever it's a higher standard. But, sometimes you need those higher standards to protect the general public.
Absolutely, and it's the FDA is the one that put the higher standards into effect, and it'll be very interesting to see how all of that changes. In 2 weeks or whatever it is when the new administration takes office. I see that the Trump administration is planning on rolling back a lot of regulations, and we have a lot of concern about what safety regulations are going to get cut back. This could very well be one of them. Food safety. It does cost money to test, and they have to throw away possibly contaminated products. So I'm curious how that's going to shake out.
Interesting. It's like a double-edged sword for plaintiffs, firms, and attorneys because, we help get people compensated for their injuries. And
Absolutely.
having something like this is going to enrich plaintiffs' attorneys when you roll back. But on the other hand, you're getting rid of a lot of safety and folks are going to get injured. So
Right.
I'd much rather have the higher safety standards. That's why I went to law school, is to help folks.
Absolutely, it's the same thing here. I would prefer very much if we're put out of business because nobody gets hurt and injured anymore. That's not likely to happen anytime in our lifetime, I don't think. So we'll keep representing and helping people who were injured, and I certainly hope nobody's ever poisoned with food poisoning from Blue Bell or any other ice cream again. Because of the local Texas connection, I'd feel bad if we did have to represent somebody against Blue Bell. But sometimes you have to put your own personal interests aside like that and do what's right for the client.
Yeah, absolutely. And it's unfortunate that those type of problems still exist,
Yeah,
given that
absolutely.
there are so many federal regulations.
Right, and another area that people are hopeful that we're going to see a lot better safety with is the self-driving cars. The writing's on the wall. Eventually, at some point, where we drive ourselves, that's going to be the rarity. But there's been some accidents with the companies with self-driving cars, and it brings up a really interesting point because sometimes accidents just plain aren't avoidable. That another car runs a red light and runs in front of you or whatnot, and somebody has to decide how that accident's going to happen. Does the driver prioritize his own life, the life of people in other cars or property, or how do they do that?
Sure.
So it'll be interesting to see how the law starts to develop because if Google has a self-driving car, what's its first priority? I'm not the biggest sci-fi fan in the world, but I think didn't Asimov have like a law of robots that the first rule is to protect human life?
Yes, yeah.
So what happens if the car, somebody is going to die? Is it the driver of the car or is it a pedestrian? How do you decide? How does the car decide who lives and who dies?
Interestingly enough, what happens if you have two self-driven cars? How do you decide who's at fault? From a personal injury standpoint, because you have to go after the person. We can only represent folks who weren't at fault and who were injured. So do we sue the company? Are they insured? It's an interesting way to think about where it's going to go.
Absolutely. I think a lot of very interesting laws are going to get developed, and it'll be very, from a legal perspective, an entertaining time to be involved in such a critical new development area of the law, because as you said, the cars are going to have to decide, and we have to then figure out, what the fault is. So if Google makes a self-driving car and it says, I'm going to prioritize the driver of this car's life at all costs, and Apple makes a self-driving car that says, I'm going to prioritize the life of others at all costs, geez, wow, what do you do for an unavoidable accident, right?
I have no idea. It sounds like we might have to have some crossovers with the law with maybe some patent attorneys and some personal injury attorneys.
And some ethicists, too, I'm sure. I'll tell you the one thing I do dread about those cases is, it'll be really expensive to try them with having to go through all the code and do all that. That does not sound like a lot of fun.
No. That's why I don't practice patent law.
Right. Our hats are off to our brothers and sisters in the bar that practice patent law. It's a very complicated and very dry area of law. I wrote a provisional patent for some Bluetooth thing back when I did tech stuff, and it made me want to pull my hair out. I'm sure for your stuff it had to be the same.
I enjoyed the folks I worked with. I enjoyed some of the clients, but yeah, it's just, you're sitting in a cubicle drafting patents. I still have a lot of friends who do it now. They're sitting with the USPTO. So hats off to you.
Yeah, absolutely. And Dustin mentioned, clients, and that's one of the things that we really enjoy the most is we represent, for the most part, almost exclusively just average, everyday individuals. Yeah. It's pretty rewarding, I think.
I like it. I truly do. I've been in 3 accidents myself, so I understand. I put myself in the shoes of the client, and so I can seriously just walk them through every single step of the way, and knowing that they can trust me because I've been there. And
sure.
So yes, it's very, very rewarding.
And the last accident you were in, you were still in law school when that happened, right?
That's correct.
But did you see things differently going through those eyes?
Whew. Yes, I did. and it was usually end over end on my motorcycle.
We don't let Dustin ride motorcycles anymore because we want to keep him around.
I'm on my third one, so the wife said no more motorcycles. But yeah, I certainly do, because that was the most extensive accident I had been in. I had to spend the night in the hospital. I had luckily saw the guy blow a red light on the last second, so I stood up on my bike, preventing my leg getting crushed.
Right.
So yeah, I mean, I'm still injured today. I still have back spasms occasionally, so I get these long-lasting injuries too, and the need to have an attorney represent folks for their future meds.
Absolutely. And if I recall correctly, you got the maximum amount of the other driver's insurance policy in that case, didn't you?
Yes, that's correct. In California, it's a minimum policy of $15,000.
Right. And that $15,000 sounds terribly low for what you went through.
I mean, that was just my hospital stay and
Right.
the EMS trip there. Yeah,
Now, did you, after everything was said and done, did you end up with anything in your pocket?
I did. There's something called UIM. So if you get hit by someone and they have the minimum policy, but your damages exceed that, if you have underinsured or uninsured motor vehicle coverage, you're actually able to make a first-party claim. So you're just going after your own insurance for the difference.
Right.
And that's exactly what I did out in California. I had a $25,000 policy, so I took the 15 from the third party and then the difference. So I got the additional 10,000.
Now, when you talk about first party and third party, I didn't understand that until I went to law school, that if you have a contract between you and your insurance company, you're the first party to that contract, versus if somebody else hits you, you were a third party not to that contract.
That's
so that's
correct.
what the difference is.
Yeah, I mean, even in my that was my third year of law school, I still didn't understand that until I got into the accident. So, I mean, I
Right.
could go through half of law school and still not understand the insurance.
Right. And now you work with insurance every day for our clients.
Yes.
So
Yes.
do you help them collect for the UM and UIM?
Of course, yeah. If the damages are exceeding the third party, the other party, the at-fault party's insurance, absolutely.
Right, and one of the things that we like to do at the firm is if a case comes in and it's going to be, someone's really injured and it becomes an issue how much insurance there is we pay services to do searches to see what insurance policies there might be out there. I know we're handling a trucking case right now that another law firm rejected because they didn't think they were insurance involved, but we dug up a policy and we think we'll be able to get a recovery for the client now.
Yeah, I mean, even if we aren't able to get a recovery from the insurance, trucking companies have assets. And so,
Right.
this person nearly died. So they're entitled to at least their medical bills getting paid and their pain and suffering for their future medical bills as well.
Absolutely, that they should get as much recovery as we can get for them, and part of getting a good recovery is knowing how much is out there. So we will do, if the case warrants it, we'll do an asset search. We'll hire an investigation firm to find out how much is out there, because somebody might have only a small insurance policy. What's the limit in Texas? The minimum one?
The minimum is $30,000.
Right.
30,000 per person and $60,000 per accident.
Sure, and somebody might have only a $30,000 policy, but they might have $500,000 worth of assets, and that would something that would be able to come into play, and we would search for that.
For example, how would you determine what a case is worth here?
Yeah, one of the biggest values that drive up what a case is worth is first and foremost the medical bills. If you have $50,000 in medical bills, well, I'm not going to be happy with any settlement that doesn't at least cover the medical bills.
Sure.
So we go up from there, and then we use a variety. We have a very extensive law library that shows what injuries have been valued at by juries and settlements across the country. I think you were looking one up earlier today, weren't you?
It was, yes. We actually had a potential client call us and had migraines, concussions, and I believe a neck injury. And I was able to just go to the case evaluation handbooks, look at the average settlement and jury verdicts for the years, going about 5 years back. So all the way back to 2011 with the average settlements and jury verdicts. So we are able to actually put a pretty good number on what the case is worth going in. So that way when we start negotiating with the insurance company, we pretty much know what the real value of our cases are.
Right, and it's very powerful, if the insurance company offers $10,000 to be able to say, well, in the past 5 years, there's been 27 jury verdicts for similar injuries that have been $30,000. So
Sure.
you might not want to offer 10. You need to come up with something a little bit higher. And unfortunately, the biggest constraint for us is sometimes, we do represent people that have very serious injuries, but there's only a $30,000 policy, and it's difficult to get more than that. So one of the things that we do is we try to get their medical bills lowered, right?
Yes.
How do we do that?
Well, we just call them reductions in-house, and simply we just start a negotiation process with all the medical providers. So once we get a settlement check, it's our duty to the client themselves to make sure that we get the most money in their pocket, because they're the one that's going to have to live with the memory. They're going to have to live with the injuries, and unfortunately, probably their future injuries as well. associated with this accident. So, yeah, we'll go to each individual company or provider and say, hey, would you be willing to take a little less in your pocket just to make sure he gets more, or he or she gets more?
And we don't charge anything for that service, do we?
Absolutely not, no.
Yeah. One of the things that's nice about that is some people, they're inclined to try to settle their own accident case. And, we, of course, think you'll do better off if an attorney helps you, if not us, some other firm. But, we're pretty seasoned at negotiating with hospitals and doctors and ambulance companies. And, some folks never even, it crosses their mind that, you mean I could get my emergency bill lowered? Yeah, absolutely. I mean, we do that as often as possible and as much as possible. And I think we probably do a better job at that than somebody who's never had to do that before.
Honestly, that's one of my favorite things when a client comes in to say, sign their settlement check and they see that we've got 50% reductions on all their medical bills. They're like, how did you do that? It's like, well, we've been in the business. We know how to negotiate and what they're willing to take. So it feels nice to get almost their entire medical bills reduced.
Right, absolutely. It's one of the nice things we do and we look for any way that we can to put as much money of our clients, money into our clients' pockets as we can. That's one of the services that we do. We try to get the largest settlement possible and then try to put as much of that possible in their pocket. So something to keep in mind if you've been injured and have medical bills that are piling up. We can help not only get money to pay those bills, but we might even be able to get those bills reduced. And when we do that, there's no negative effect for the client, correct?
No, not at all. And most of the time, they're not paying out of pocket when they hire an attorney.
Right, and it doesn't go on their credit report or show that they paid less than agreed or anything like that.
No, absolutely not. No.
Yeah.
No, they wipe it clean once they sign that.
Yeah, and the medical companies, they know the drill. If somebody hires an attorney, they understand they're probably going to have to take less money than they might have billed unless that there was catastrophic injuries and there was a whole lot of insurance coverage or other funds available. I mean, if you get $1 million settlement and there's $100,000 in medical bills, the companies are much less likely to want to reduce in those cases.
And they're much less likely to reduce without an attorney being involved.
That's also true. Yeah. Right, because they talk to us and treat us a lot differently than if you call and say, hey, Mr. Hospital, I'd like to get my medical bills reduced. They might laugh at you versus they know they're going to have to talk to us. So that's something else.
If they want to get paid, they usually wrap it up with us.
Right, and they almost always want to get paid. Yeah, I think that is definitely a good service that we offer, and I'm happy we're able to do that for people. Dustin and I were talking earlier about FaceTime, and that's one of the services that we use to communicate with our clients. You can call or text us 24 hours a day. If you want to do video conferencing, we have FaceTime for Apple users. We have Skype for everybody. And we have email, and the email is help@justinian.com. We got an email earlier today that we answered, and a person is scheduling to come and chat with us in person. But the question was pretty good, and I thought we'd share it here today. Sure. The person was in a car accident a couple of weeks ago, and they didn't think that it was very serious, didn't really feel very hurt, but a couple of weeks later now they're still pretty sore and starting to have some headaches. Is that somebody that we can help, Dustin?
You can. Basically what the insurance might or might not say, depending on this gap of treatment, because the longer you go without treating, well, the more likely you are not injured. But life happens, and usually a week, 2 weeks, possibly 3. If you've been self-medicating, taking, pain pills or heating pads, yeah, I think that's certainly something that we can help with. Right,
and Dustin said, gap in treatment. That's insurance code basically for we think your guy's faking it, and we get that all the time, that insurance companies don't think that our clients are really hurt. Many, maybe even most of our clients, they don't have the kind of jobs that they can just take off and go get medical treatment whenever they feel like it. We have a lot of people that, they'll work through the pain, they'll shake it off, they'll be okay.
Just hoping it goes away.
Right. And you've had injuries before that you would hope would go away and just don't, right?
Yeah, absolutely. And you sit there weeks, or at least a week, and you're like, okay, I'm still sore. What's going on? Now I should go see the doctor. It didn't go away for 6-7 days, especially with those who have like a higher pain tolerance.
Absolutely. The higher your pain tolerance, the more likely you're willing to try to work through things. And unfortunately, the longer you wait before getting treatment, the more damage you're doing to the value of your case. Because, I can use myself as an example. I injured my hand a while ago, several months ago, and I've just been like, it's going to be all right. I'll be fine. No big deal. It turns out I probably am going to need hand surgery, and it was my own fault. I was being careless and hurt it, so there's no lawsuit or anything. But if somebody had injured me and I waited a couple of months before I went to the doctor, it'd be a huge uphill battle because.
It would.
Yeah, I mean, to be fair, there's no way of knowing, well, maybe you really just injured it yourself and it wasn't the accident.
Yeah, I mean, that's exactly what the insurance company's going to say. Well, during this period, what were you doing? Did you happen to hit it on anything? The list goes on and on.
Right. So if you've been injured, the best thing for you to do for your peace of mind, at least, is to get checked out from any kind of medical thing that you think you might need. It's better to err on the side of going and getting checked out than not. Maybe you get peace of mind and they send you home and there's nothing wrong, or maybe you do find out that you need something. We've had folks that have come to us that we've found very serious injuries because they've gone and set off and they've gotten an MRI or a CT scan and they didn't know that they were injured.
No, absolutely not. They just thought they had some slight back pain and turned out they had a bulging disc with some numbness going down to their fingers. I'm like, I don't even know how you're walking around right now, but they waited a couple weeks before they sought treatment.
Right, it happens, and we understand that life happens, but one of the concerns I think that people have is I don't want to have to go get into the medical bills and pay for that. Is there anything we can do to help?
No, that's one of probably the biggest advantages of having an attorney. You don't pay out of pocket. We do something called a letter of protection, which is, in layman's terms, it's just a lien against your medical bills. And so you don't pay anything out of pocket. You just treat until you're done treating, and then we negotiate. And so, yeah, it's a huge advantage.
Right. It makes it able so if you can't afford to pay for your medical treatment, we can protect the medical provider that's treating you, so you will get treated, you will get to heal, and you will get better. And honestly, that's the most important thing is we want you to get better. Mm-hmm. We can't really even try to settle your case until we know that you are healed, because otherwise it's hard to value your case. Mm-hmm. So if you've been in an accident and still have some lingering pains or doubts if you were injured, but don't want to be out of pocket any costs, you can give us a call and we can get you set up to get in and have a medical provider take a look and see what's going on with you.
Yeah, absolutely. So if you have been injured in a car accident, please give us a call, 512-980-0000.
Or maybe you've heard it another way, 980-0000. Thanks, everybody. This is Justinian Lane of Justinian Associates.
I'm Dustin Fox with Justinian Associates.
And we will see you next week.